Hello and welcome to Regional Counsel, presented to you by the Singapore Academy of Law. My name is Nicole and I am your host for today. Regional Counsel is a series of short video podcasts on legal content catered to in-house counsel who are new to ASEAN regional work. This series is not meant to be a deep dive, but to equip in-house counsel with tips and tricks from experts to navigate the challenges faced when dealing with jurisdictional specific quirks. In today's episode, we will be delving into Indonesia law with an expert, Associate Professor Gary Bell of the National University of Singapore. Hello, Professor Bell. Thank you for joining us today from Canada. Could you share with us your background and your professional expertise?
Thank you very much for inviting me. I'm very pleased to be here. I've been teaching in Singapore for 29 years, but the reason I came to Singapore, strangely, is Indonesia, actually. My own background is I'm Canadian, as was mentioned. I happen to be here for the holiday right now, but normally I'm in Singapore. I have been trained in both civil law and common law at McGill University here in the city of Montreal. McGill gives you 2 degrees, one in civil law, one in common law. And the civil law they teach you is the civil law province of Quebec, which is based on French law, right? And surprisingly, maybe to some of your auditors right now, the civil law that I've studied is the same basically as the Indonesian law, because the French civil code that we use, is the code of the Dutch, because Napoleon invaded the Netherlands, and the Netherlands were in charge of Indonesia, and they brought the Napoleon and the commercial code to Indonesia. So it would be like, for me, approaching Indonesian civil law, it's like a Singaporean lawyer trained in Singapore trying to approach English law. Very familiar.
Yes, that's right.
Something that it's a little bit different, right?
Yep.
But it's very familiar. Except I had to learn Indonesian, of course, because
Wow.
civil law doesn't have a common language, right? My Indonesian is far from perfect, but I can read. So that's why I was interested in Indonesian law. It's a long story why I came to that. I won't explain all of this, but I was very interested. I started my career at McGill, trying to do Indonesian law from Canada. McGill has an Institute of Comparative Law, but it came clear to me that there was no money for research on Indonesian law in Canada. Singapore was very interested. They had already offered me a position, and I decided to move to Singapore 29 years ago.
Wow.
So I have been teaching at NUS for 29 years, which explains why I'm in Singapore. And maybe I taught many of those people who are now corporate counsel. I've taught quite a few of the people. I do basically at NUS, I teach Indonesian law, but I teach comparative law. I also teach arbitration. I do a lot of arbitration, sometimes, many of them related to Indonesia as well, which is good because it gives me a practical aspect also, practical view of Indonesian law in practice as well, right? So that's also very, very good. I do comparative law, and I happen to be the Secretary General of the International Academy of Comparative Law as well. So that's a bit of my background.
Thank you so much for sharing. It's a really varied experience and also very in-depth, right? Perhaps now we can move on to contracts. Would you be able to share with us on the Indonesian civil law of contract?
Yeah, I'll be pleased. The law of contract is mainly in the civil code, with some things sometimes found in the commercial code as well.
Okay.
So you start with the civil code because most of the rules of contract law are in there. One thing I must warn people, often I get questions, people call me and say, we're looking, for example, for how do you enforce your contract, and we can't find anything in the part of the code on contract law. You have to think in terms of civil law. Contract law is part of the law of obligations. So the civil law person will think about enforcement of obligations, which includes contracts, right?
Yes.
So look at the whole book of obligation, not just a part of that book that is on contract law, because the whole book applies to contract law.
That's a very useful tip.
Yeah, in that book, the basics are there, but it's called in Indonesian the Kitab Undang-Undang Hukum Perdata, right? So this is a book of private law. So as I mentioned, it's an old book. I mean, the original French one is 1804. In Indonesia, it was adopted in 1847, and basically it hasn't been amended since. It's not unusual for a civil code to be very old. French went with it for 200 years without any significant amendment to the code. But that doesn't mean the law doesn't change, because, as I mentioned, the jurisprudence and the doctrine can make the law evolve. Now, what do you have in there that are important or interesting to mention? First of all, I mean, offer and acceptance. We have to understand, and I'll come back to that in a second, there is no requirement of consideration in civil law. So you can have a contract in which one party obliges himself to do something and the other party just accept without having to do anything in return. So there's no requirement of consideration. I'll come back to that in a second. But what does it mean for offer and acceptance? When you make an offer and the other person accepts the offer, let's say you make an offer for 10 days to accept you have 10 days to accept my offer. The other person says yes. You can't revoke the offer. It's binding. Now, common law, you would say there's no consideration. Even though I said 10 days, he didn't give me the consideration. It's not binding. In civil law, it is binding. So you have to be careful if your draft contract says Indonesian law applies, or you happen to be in Indonesia, and Indonesia, therefore, Indonesian law applies. Don't make offers unless you are sure that you can keep them open for the number of days that you give them. And even if you don't have a number of days attached to the offer, there's really a very strong commitment to good faith. And there's a requirement that all obligations, contracts must be performed in good faith. So the revocation of the offer must not be unreasonable. So if you make an offer on a Sunday and you know the guy has to talk to his bank, you cannot Sunday night cancel it, because you didn't give him enough time. And the court could possibly reverse that. So it's important to understand that. Also, there's no postbox rule. The acceptance is efficient to become a contract only when it is received at the other hand. Nowadays, most things are done electronically, so it's less of a problem,
Yes,
right?
that's right.
But it's almost instantaneous. But nonetheless, the idea is that what you have to prove is not that you've sent it, it's that the other side has received it.
Wow.
So that's how you prove that you have a contract. So it's important to keep that in mind in terms of evidence. The other thing that I should mention is, and I've mentioned it already, but the fact that there's no consideration. So it means that some contracts exist in civil law that you would not see as contracts, or that you would need to give some symbolic consideration in order to make it a contract, or do it under seal, which nobody does anymore.
Yes.
But you know, that's a possibility as well. So the contract of gift, for example, there's a whole chapter on the contract of gift. A gift is a contract. In common law, it's not a contract,
Yes, it's
right?
not.
No, it wouldn't be unless it's under seal. Now, in the civil law, a gift, you actually have to have it in notarial form, right? There's a writing requirement in front of a notary. I'll come to that a little bit later in the form of contracts. But one of the things that is important to realize is that it applies not, okay, the gift has to be in a certain form. But what if I promise to you, I'll paint your house? That's not a gift, that's an act, right? And you say, okay, sure. Well, I'm bound by that. It's what we call a unilateral contract, not to be confused with what you call a unilateral contract. I don't know whether anyone remembers the case of the smoke balls, right? Carbonic smoke balls.
Yes, smoke balls, yes.
Yes.
Every student of English law would know.
Yeah, that we remember that the newspaper advertisement says if you do this and you get sick, you'll get a reward, right?
That's right.
And the court said that's a unilateral contract accepted by performance, right? That's what you call a unilateral contract. What we call a unilateral contract is not that. What Carbonic smoke ball did, we called simply a promise of a reward. The unilateral contract for us is a contract that is enforceable, in which one side promises something and the other side promises nothing.
Okay, right? That's so interesting.
So that's a contract, which is, Now, you might say that this is very theoretical. Professor Bell is talking in theory here. Not so much. True, most people, most commercial contracts will not want to give something without anything in return, right? But think about modification of contract. Could you give me one more week? Yes, I'll give you one more week. That's not enforceable unless you give something in exchange, right? In the common law. You need fresh consideration. In civil law, it is enforceable. It's a unilateral contract, but it is a contract. You made an offer. I'll give you one more week. It's accepted. That's it. You don't need consideration. So this is not theoretical.
Yes, it's not theoretical at all. It has practical implications, like you said, to variations and enforceability.
Yes. So you have to be very careful when you say, I agree, it's binding. If the other side asks you for a week and you say, I agree, the contract is automatically modified. So you have to take that into account. The other thing that there's many things to say. I can't possibly say absolutely everything about this, but the issue of consideration also arises in many other contexts. Anyway, let me move on because there's so much to cover.
Sure.
The other thing that is interesting is once you have a contract, how do you interpret the contract?
Interpretation, yes.
The common law has the parole evidence rule, which is an evidence rule, as the word saying, but it's also a rule of interpretation. In the common law, you have your contract, you look at it, and what is the contract is what a reasonable person, a third party, in the same position of the parties, would think the words mean, right? You will not look at the negotiation. You will not look at all the extrinsic evidence. You will concentrate on the contract, right? In the French Civil Code, Indonesian Civil Code, there's an article of the code that says if the contract is not clear, if there's two possible interpretation, we should search for the intention of the parties rather than the literal meaning of the words.
Oh, okay.
It literally means exact contrary of the common law.
Yeah, it's the exact opposite.
The exact opposite. So basically, the court, the arbitral tribunal, if following the civil law of contract, will have to look at the negotiations, etc., etc. That has a lot of consequences. For example, all of this becomes relevant with respect to document production, for example, discovery.
Yeah, discovery
right?
processes.
So all of this is now right. So you have to know which law applies to the contract, and then that has consequences. If it's civil law, you can look at an awful lot more things, including performance of the contract after the contract, as evidence of how you have interpreted the contract, what you meant. I often give the example if two parties from different countries say $100,000 US, $100,000. The question is which dollars, right? Is it US or Singapore dollar or right, or Hong Kong dollars? And normally in the common law you can't look at the negotiations, right? But in the civil law you can look at the negotiation. Maybe something is cleared there. But if the debtor has paid in US dollar all along, and the creditor has accepted, that's a sign that is what they meant. So subsequent behavior can also be used in interpreting the contract. So be careful in negotiation and be careful in how you implement the contract, because that might lead to an interpretation of the contract that you don't like, right?
Yeah. That's very useful. So in-house counsel friends, if you're listening in, Professor Bell has just given us very useful tips about contracting, even from offer and acceptance. These are common law concepts that we're familiar with, but in the civil law tradition, that might be different. And also in terms of, things like there's no postbox rule in Indonesia, and, it depends on when the party has received, notice of it. And I think our common law understanding really is very different from the civil law tradition. And one could even argue that the civil law tradition is a bit more onerous, I think, in this context, based on what Professor Bell has shared so far.
I will say something that the civil law has a more, and I don't mean that in a critical way, but civil law is much more concerned with just fairness,
Yep.
morality, good behavior,
Yes.
good faith.
Yeah.
Um,
These are important concepts, actually.
yes, this actually justifies all kinds of rules. No need for consideration. You promise, perform.
Yeah.
If you're a good person and you promise and promise is accepted, you would perform. So they encourage this. Now, this lead to that there's some disadvantages. The advantage of a common law is that everything is going to be clear in the contract because you know that's the only thing. So you're going to make all the efforts to put everything in the contract.
Yes.
Civil law sometimes is a bit less concerned because you're going to look at everything. So each of these two systems has its own advantages,
Yeah.
right? I'm not trying to criticize, but you have to understand that in a civil law, you are to a larger extent held to your word and made to perform nicely. I don't know how to put it differently, properly.
Yeah. Is there perhaps an equivalent of like a contra proferentum rule, for example, in the civil law tradition?
Yes, we have the same kind of rule as well. That the obligation, if all fail, right, we can't decide, the obligation will be interpreted in favor of the debtor of the obligation.
Okay. That's useful to know.
In this case, if we can't decide whether it's US dollar or Singapore dollar, it's going to be Singapore dollars because that's less difficult for the debtor to perform. Singapore dollar being, at this point, less value than US dollars. So we have these kinds of rules, but you have to understand it's a general obligation. The article of the code says every contract must be performed in good faith. And I'll come back to that. Well, let me continue with that. This means also, there's another article that says that the contract extends not only to what's written in it, but also to what is required by equity, equity meaning good faith, right? By equity, the law, and custom. So custom we have in the common law as well, right? This is customary rules, so that's fine. Obviously, what's required by law is also part of the common law, but what is required by equity is different. And I don't mean equity in the common law sense of equity. I mean just fairness, right? So sometimes the court will say, this is really not fair, and they will correct the contract. A bit too much, actually. Indonesia has a tendency to intervene. The courts have a tendency to intervene a little bit too much. The French and the Dutch will intervene. If something is wrong, unfair, they might intervene. They might even intervene if the contract is unfair. To say that's unfair. I'll give you an example of that. The way that hyperinflation is dealt with. There are cases of after the war in Indonesia, the court saying, okay, before the war you promised to pay that much for this house, but now this price is ridiculous, right? Because of hyperinflation. So we will figure out another price. And the court imposed another price.
Wow.
So this is trying to get some fair result between the parties. And that's not just Indonesia. There was a very famous Volkswagen cases in Germany where before the war people were paid half the price of a Volkswagen. And after the war they paid that second half. But the second half was, with the amount of the second half, you couldn't buy a piece of bread. The hyperinflation went to millions of times, right? So the court said, no, you can't get a car for that price. We'll figure out what would be the price of a car today, and you paid half before, so we'll cut it by half. That's fair, right? So they will rework the contract in this way, which I don't think any common law court would do.
Yeah. It seems very unheard of. So thank you for sharing that with us. Thank you so much, Professor Bell, for joining us on Regional Counsel. If you have found this episode helpful, please check out the other episodes. This has been Regional Counsel, a production by the Singapore Academy of Law.